Welcome to today's webinar, Organized in Collaboration Between Synergy and Trial Structure. I'm Jason Lazarus, CEO of Synergy, and I'll be your MC for today's presentation. Before we get started with the presentations, I wanted to briefly introduce Trial Structure and Synergy. The Trial Structure educational program trains some of the top plaintiff attorneys in the country by focusing upon three core concepts: case structuring, witness preparation, and persuasion skills. Through intensive workshops, coaching, or private one-on-one sessions, attorneys strengthen their ability to persuade jurors through organized reasoning, emotional appeal, and compelling evidence. They build credibility and connection while dismantling defense arguments. Today's webinar features three of Trial Structure's top educators, Chuck Bennett, Ilya Lerma, and Jamie Holland. Chuck is filling in for Alejandro Blanco, who was supposed to present today, as he is immersed in the Camp Lejeune case and could not join us. In addition, we have two of Synergy's top subject matter experts today presenting about lien resolution, as well as Medicare secondary payer compliance, along with future damages quantification with medical cost projections. While Synergy offers a variety of services exclusive for personal injury law firms, our primary services are healthcare lien resolution and Medicare compliance. By utilizing Synergy, law firms can be more efficient and profitable. For example, a 5-lawyer firm that works with Synergy saved over 4,200 combined hours of paralegal time and attorney time, along with achieving in excess of $540,000 in operational savings by partnering with Synergy. With that preliminary introduction out of the way, let's get to our first speaker, Charles Bennett. His presentation is entitled Exposing the Defense's Use of Psychological Warfare in Trial. Chuck will help you learn how the defense uses psychological warfare at trial to defeat your evidence of duty, breach, and causation by using cutting-edge linguistic tricks to paint a picture for the jury that your client's case is about frivolous lawsuits, greedy lawyers, and a litigation lottery. Let me introduce Chuck. He is a trial lawyer and a trial consultant. Chuck is the principal attorney for Bennett Injury Law. He represents his clients in commercial 18-wheeler crashes, wrongful death and catastrophic injury, traumatic brain damage, motor vehicle crashes, and workplace injuries. Charles is known as a tough, aggressive litigator who uses the tools of the law to put maximum pressure on the defense to force them either into paying full value for a case or taking unreasonable positions at trial. As a consultant, Charles operates Trial Structure LLC, where he is one of the principal consultants that prepares opening statements for trial lawyers prior to trial. Chuck, the floor is all yours to demonstrate the power of trial structure.
Thanks, Jason. So let's talk about how the defense uses psychological warfare at trial against plaintiffs in personal injury cases. And where this kind of started from is over the years, I've noticed that I've taken good cases to trial, and other lawyers like me have taken good cases to trial where we can prove every element of the claim. We can prove duty, we can prove breach, we can prove causation, and of course we can prove damages. And yet we go into trial and we just have the worst results. We get far less than we thought we were going to get, or sometimes even zero on a rear end collision. And for the longest time, it just made no sense to me, or we just couldn't figure out why this was going on. We'd been taught in law school that that if we proved all four of those elements, duty, breach, causation, and damages, that we should be able to win money for those claims because we've proved everything. But it turns out that that's not true. And one of the first cases I learned this on was I had a rear end collision case in a county north of Dallas called Collin County, which is north of Dallas. And it's a pretty red county. There's a lot of conservative people there. And it's always been historically known as a really bad county to try cases in. But we had a good case. It was probably my second year in practice. And a buddy of mine at the law firm I was at that time came in and was like, "Hey, Chuck, you want to try a case?" And I'm like, "Yeah, absolutely." And so we take it down and to the courthouse, and it was just a simple rear ender where the defendant is coming around a turn on a service road, and our client is stopped at the yield sign, and she just runs into the back of him, and she's got her neighbor in her passenger seat, and she's got two of her kids in the back seat. And the defendant was a 25-year-old waitress who showed up to court in blue jeans and tennis shoes and had a Texas Rangers jersey on. And in voir dire, my co-counsel, my buddy from the firm, was just going to kind of do a normal plaintiff's voir dire where we talked about duty, we talked about breach, causation, and damages. We tried to get the jury to understand that there's certain rules that we have to abide by, that we've all agreed to abide by in driving cars, and if we break those and we cause somebody harm, that we're entitled to those damages. And most of the way through voir dire, it seemed to be going fine. We were getting good answers. And then this one guy who's about 3 rows back in the left, on the left side of the panel, he raises his hand. And so my buddy calls on him, and the guy stands up, and nobody else, the whole voir dire, stood up, but he stands up and he looks at my friend, the co-counsel, and he goes, "Lawyers like you make me sick. You take the insurance money and you sue poor little girls like this personally." And, we all whipped around and looked at the judge, and the judge, who was a conservative judge from this county, was just like, "Well, move along, counsel." And I mean, it was unfair, and it poisoned the whole jury panel, but the judge didn't see anything wrong with it. And the panel was just automatically already angry with us. And what's interesting is that the defense lawyer, when it was his turn to do voir dire, he stood up and he said, "Folks, back in the good old days, we used to be able to work things out amongst ourselves. But then a bunch of smart lawyers put on their fancy suits, and they went down to the state capitol, and they created this law called the Open Courts Doctrine, which allows anybody to sue anybody else, any one of us, for any reason. How do you guys feel about this Open Courts Doctrine?" And just the room just exploded with all of this frivolous lawsuit, and lawsuits are terrible, and all of these different things that were really bad for us. And then in closing, the defense lawyer said, the plaintiff was probably in some pain after the crash. I mean, we can believe that. There was some property damage. And so he had every right to go to the hospital and get an x-ray. And he probably had, give him $500 in pain and suffering. So it's $900 for the x-ray and $500 for pain and suffering for $1,400. And the jury went back and deliberated for an hour or less and came back and gave us $900. And they just stormed out of the courtroom angry. And it took me a long time to try to figure out what was going on there. And I remember we were driving back to Dallas after that case, and my co-counsel was saying, "Wow, it was a bad jury and a bad judge, and the defense lawyer did this and the defense lawyer did that." And I was like, dude, if we don't learn from this experience, if we don't try to take something out of it, like, why did we lose a case where we proved every one of our elements, then why are we taking these cases? Why are we taking these smaller cases where we're asking for $100,000 or $150,000 and it's not making a huge impact on our client's life? And I've seen it over and over and over in my career, where the defense comes in and they seem to have these jurors almost in a trance, where they just believe everything the defense lawyers say. The defense lawyers talk about something for nothing. Litigation lottery. I actually had a defense lawyer put litigation lottery on a PowerPoint slide in his closing in federal court. Open courts doctrine, like the voir dire I just read or talked about earlier. Of course, frivolous lawsuit, greedy plaintiff. All of these psychological attacks are consistently presented by defense lawyers on cases really small and big. And for some reason, they really work on the jurors so that they get the jurors into almost a trance, believing the defense case before we get an opportunity to do our opening or present any evidence. And so I went on a multi-year crusade to try to figure out what was going on here. And a lot of what we teach in our organization is to understand that pre-existing stories in the human mind have a huge effect in how human beings understand the world. For example, I'm a former basketball player. I'm 6'8". I played professional basketball in Europe for 8 years after college. And so I see the world in terms of basketball. I see law in terms of basketball. My job in in bigger cases with where I need multiple experts, where I need multiple lawyers working, is I'm trying to create a team where I have different players. So we can't have everybody being a center or everybody being a point guard. You know, not everybody can be 7 foot tall, not everybody can be 6 foot tall, or else we don't have a basketball team. And so I think of the world in terms of basketball. And I've got a good friend who's a black belt in jujitsu. He sees the world in terms of jujitsu. Another friend that plays football, played college football, and he always talks about football plays and how that kind of applies to trial law and everything else he does. And so it started me thinking about, what is the story that the jury hears, and why do they hear it that way? And are there certain stories that are common amongst all of us? There's a book called The Hero with a Thousand Faces by Joseph Campbell, who argues that if you take a look at myths and stories around the world by different cultures that have never met and from different times and different geographical locations, they all kind of follow the same pattern because they're easily understood by the human mind. But more importantly than that is like the stories that we tell throughout our lives and the stories we hear throughout our lives, we use to analogize to what's going on in our life now. Just like, I've been around basketball players for so long, from up until the age of 30, from elementary school all the way to 30, is like, I think of the world in terms of basketball. I also think of it in terms of music and, some of the other things that I've done in my life, skills that I've learned and whatever. So I usually do this when I'm in front of an audience, is I'll say, once upon a time, there's a little girl in the woods. What story is that? Just from that beginning. And normally the first one I get is Little Red Riding Hood. And one of the ones I sometimes get, or usually get after a couple, is Goldilocks and the Three Bears. And so based just on that information, once upon a time, there's a little girl in the woods. I asked them if one person in that jury panel is thinking about Little Red Riding Hood, when I just say that little short sentence, once upon a time, there's a little girl in the woods, then who do they think is the bad character in the story? Meaning, who's the bad character in Little Red Riding Hood? It's the wolf, right? Now, if they're thinking of Goldilocks, when I say once upon a time, there's a little girl in the woods, who's the bad character or characters in Goldilocks? It's Goldilocks, right? The poor little three bears had their porridge taken by that evil Goldilocks. But that matters because I haven't given the jury enough context for them to understand the whole story. So I have to give them enough context to where they do understand the story. And from the defendant's point of view, what context do jurors have when they walk into the courtroom? And the question is, what stories have they heard about these types of cases that they've heard over and over and over? Well, what are the stories that the insurance industry tells us? State Farm's Like a Good Neighbor, accident forgiveness, you're in good hands. And of course, this guy, the mayhem guy, who goes around just destroying the world and everybody just walks away. And it makes it seem like small property damage cases or lesser property damage cases, people ought to be able to walk away. And the point here is, if we hear these stories over and over and over, like they're played in every single commercial break for almost every show that's watched on regular television, then we start to believe it because we hear it so often. And so when we think accident forgiveness. Like a Good Neighbor, we think of State Farm. You're in good hands. We think of these insurance companies as protectors, and the stories they tell where they're calling our cases frivolous, where they're saying we should forgive accidents, that mayhem is something that insurance companies protect us from. Then they think when they walk in and they don't see insurance there, that we're actually suing this poor defendant personally. And it's a huge problem. And it's intentional. It's been over the last several decades. Another thing that insurance companies are doing is the open courts doctrine voir dire, where they're actually giving the insurance defense lawyers scripts to run against us in voir dire, in opening, in closing, questions to ask on cross-examination of the plaintiff to try to make the plaintiff look bad or try to fit the case into a pre-existing story that the jury has that this case is frivolous. So all of these things combine together to where the insurance defense attorneys can just kind of walk into court and say, well, it's a car crash or a car accident, and the jury immediately knows or thinks that the case is a small property damage case where we're suing the defendant personally and there's no insurance involved. And that's a huge problem. A friend of mine in Dallas tried a case against the same defense lawyer in back-to-back months. And they were both car wrecks. He's a car wreck lawyer and an associate at a bigger firm, this defense lawyer. And the guy did the same voir dire, the same opening, and the same closing in both cases. And one of the voir dires he did was that open courts doctrine voir dire that I talked about earlier. Back in the good old days, we used to be able to work things out amongst ourselves. But then some smart lawyers put on their fancy suits and went down to the state capitol to create a law called the Open Courts Doctrine, which allows anybody to sue any one of us for any reason. And when I look at this voir dire, I notice that there's some very specific psychological phrases that are used to influence the jury without the jury or the plaintiff's lawyers or the judge even understanding what's going on, because they happen so fast in their unconscious. The first one is how this voir dire starts, which is back in the good old days. This is like once upon a time. It's called a regression move that therapists use and that storytellers use to try to get the listener to get out of the room that they're in, like the room I'm in now, and in their mind go back in time to think about another time. You know, back in the good old days, we used to be able to, it's kind of like Make America Great Again. Same kind of concept is get them out of the present and into the past so that they can trigger the stories that they're trying to tell. We used to be able to work things out amongst ourselves. This is called a group formation move. What the defense lawyer is doing in this case is putting himself in the group with the rest of the jury panel and ostracizing the plaintiff's lawyer. And that's a very powerful technique that not a lot of plaintiff's lawyers are able to counter because they don't know and they're not expecting it. But it can happen. This is the first 5 seconds of his voir dire, and he's already regressed the jury into a prior time in their mind and created a group with the defense lawyer and the jury panel in the same group, and the plaintiff and the plaintiff's lawyer separated. And he uses the word but then. But is a hypnotic transition word. The word but cancels out everything that comes before it and signals to the mind that there's a change coming. And it's a significant change. So it changes the story here. But then some smart lawyers put on their fancy suits. This is obviously Fox News undercurrents, where they're signaling the liberal elites that the conservatives talk about all the time by trying to put us as plaintiffs lawyers as the liberal elite lawyers that are here to cause our country to go into some sort of communism where it's nobody can get ahead because everybody's the same. And then went down to the state capitol to create a new law. This is like legislating from the bench. And again, the elite liberals trying to ruin this country. Open courts doctrine in itself, they've used that name to signal frivolous lawsuits automatically within the jurors' minds. And then this last sentence is something that reinforces the group formation that was done in the first sentence. It allows anybody to sue any one of us for any reason. And again, this last phrase, any reason, is another coded phrase for frivolous lawsuit. So even in this 3-sentence voir dire, there's so many different techniques and psychological tactics that the defense is using here to try to influence and manipulate the jury into thinking that this case is not based on the facts. And what they're really doing is asking for a jury nullification so that if we prove duty, breach, causation, and damages, we may still lose because they've got the jury so angry thinking that this is a frivolous lawsuit. And so one of the things that this next slide shows is that the intent of the defense is to create a group with the defense and jury in one and the plaintiff in another. And our job as plaintiff's lawyers should be to flip that, is to show that what the defense did was outside the norms of our normal community behavior and the way that we expect people and companies to behave in our society, and that the plaintiff is just one of us, is part of the group. And so we have to find ways to counteract this group formation psychological warfare that the defense is constantly using on us, so that when they try to do it, the jury can see the truth of what's actually going on. And I'll close with this story. Is I have two young associates that work with me. One's a first year and one's a third year. And they watched one of my trials where where we got a good verdict on a good case. And we were talking afterwards, and they didn't have a lot of questions. I said, "What do you think?" And they were like, "Yeah, it was good. It was good. I liked it. It was good." And there wasn't much of a conversation going on because they had never seen how other plaintiffs' lawyers try cases. They'd only seen how I do it. So the week after the trial ended, I took them down to the courthouse in Dallas, and I said, "We're going to walk the halls until we find a car wreck that a judge will let us watch voir dire, and we're going to watch a plaintiff's lawyer do a normal traditional voir dire." And so we did, and we found one of the judges, who's one of my favorite judges down in Dallas County. She allowed us to sit in and watch the voir dire. And the plaintiff's lawyer was a 60-year-old plaintiff's lawyer who'd seemingly been in this business for a long time. He'd probably tried several cases. He seemed very confident about his case. And on the defense side was a late 40-year-old female and kind of an early 30-year-old female. So they had kind of a more experienced lawyer with a younger defense lawyer. And this was a pedestrian versus car case. So the plaintiff's lawyer goes first in voir dire, and he stands up and he says, "Who here has any experience with the pedestrian versus car case?" And every one of the hands in the jury panel went up. And he starts calling on just individual jury members and saying, "Tell me your experience with the pedestrian versus car case." And the stories he was getting all involved some sort of 100% fault on the pedestrian, which his client was a pedestrian, or some kind of comparative fault or some comment by somebody in the jury saying, "Well, but the pedestrian should have been watching out," or the pedestrian wasn't all the way in the crosswalk, something to blame the pedestrian almost every story. And he had a 25-minute voir dire, and for the first 22 or 23 minutes, he just talked to every jury member about their experience with pedestrian versus car cases. And then near the end, he said, "I want to talk about the burden of proof, and I want to talk about pain and suffering." And the judge was like, "You have 2 minutes left." And so he introduced those topics real quick, and the judge called time, and he had to sit down. And the defense lawyer, of course, got up and said, "Back in the good old days, we used to be able to work things out amongst ourselves. But then some smart lawyers," and she ran word for word that open courts doctrine that I've heard repeatedly from other defense lawyers. And what happened when the plaintiff's lawyer got up in his voir dire is that he allowed the jury to set the context for how they saw the case. So instead of him setting the context, he allowed the jury to do it on their own. What's your experience with pedestrian versus car case? As opposed to him saying, "Here's an experience, here's a context for how you understand this case. Does anybody have a problem with this?" Which would be a different way of doing it. And then he allowed the defense lawyer to get up and create the the group formation or the tribal formation with the open courts doctrine voir dire. And as soon as he did that, I leaned over to my associates and I said, "The plaintiff just lost the case." And he did. They got a $4,500 verdict with 80% fault on the plaintiff, and over 50% fault in Texas means they get nothing. So we need to be aware that the defense bar is doing things to affect the psychology of the jury, and they're doing it intentionally. And I'm not saying that the defense lawyers that do run the scripts know all of the language techniques and the psychological techniques that I pointed out in that open courts doctrine voir dire, but whoever wrote that thing does. And the Defense Research Institute and other institutes and insurance companies know these techniques and they use them against us. And if we don't know that they're coming, then we can't prepare for them and use our ability going first to tell the jury the truth and allow the jury to see the truth of the case. And we may be and we're probably going to be in danger of, if we prove duty, breach, causation, and damages, while the defense is doing psychological tricks and tactics and warfare, then we're going to lose most of the time, and we're going to lose big without even knowing it. That plaintiff's lawyer in the pedestrian versus car case, I'm sure that he had no idea how much psychology that defense lawyer had used against him and how much of an uphill battle it was for him throughout that case. I'm sure he felt some of that without probably consciously understanding exactly what was going on, or else he would have done some things to preempt it. So I appreciate the opportunity to present this and to kind of present my ideas and our ideas for what kind of techniques the defense bar is using. We have some ways of countering this, and I'd love to get into some of that stuff on a different podcast or come to one of our events or one of our classes. And we'd love to share this and kind of develop these ideas and these techniques for getting our juries to understand exactly what the defense is doing to them and how unfair it is. So thank you for the opportunity.
Our next speaker is Teresa Kenyon. She is presenting on insights on ERISA, FEBA, military, hospital, Medicaid, and Medicare liens. By way of introduction, Teresa is a California and Kentucky licensed attorney and director of lien resolution services for Synergy. Teresa and her team provide invaluable assistance to plaintiff attorneys by handling all types of health insurance liens and bringing them to an awesome resolution with the steepest discount. Prior to joining Synergy, Teresa spent almost 8 years with the Rawlings Group, the largest insurance claims recovery contractor in the industry. She managed subrogation operations and served as in-house counsel for Rawlings Operating Center in Los Angeles. Teresa represented the nation's top health insurance carriers, including Aetna, Blue Shield, and Health Net. She has extensive knowledge of federal laws pertaining to healthcare subrogation, including ERISA, FEBA, Medicare, secondary payer, as well as state laws nationwide. Teresa graduated from the University of California, Irvine, with a degree in psychology, and she has her JD degree from the University of Louisville Brandeis School of Law. I will now turn it over to Teresa to educate you on the nuances of healthcare lien resolution.
So thank you. I'm happy to be here. The next couple minutes are going to focus on lien resolution. So specifically, I'm going to give some insights on ERISA, FEBA, military, hospital, Medicaid, and Medicare liens, which are all of Synergy's specialties. So I am Teresa Kenyon, and I am the director of the Lien Resolution Department here at Synergy. I am a licensed attorney in both California and Kentucky. And before joining Synergy, I worked at the Rawlings Company as one of their assistant general counsels and was working on what we call the dark side, helping those health insurance carriers like Aetna and Blue Cross Blue Shield get reimbursed from the injured party settlements. So I am now here. I've been with Synergy for almost 5 years, and I've got a team of lien fighters that have over 300 years of experience in battling these liens and fighting to keep that money with the injured party. So I always love to talk about the lien team because they are the ones that are doing the good work and making sure that these liens are reduced as quickly as possible and as much as possible. As I mentioned, the lien team has over 300 years of combined experience, and many of them come from the dark side that I mentioned, come from Rawlings Company and Conduit and Optum and those other big subrogation vendors. The great part about that is that means that they've got some insider knowledge about the other side, which can then help them when they go to face off against their opponent. So we then share all that information amongst each other And so even if you didn't work at Rawlings Company, because of the conversations that we have internally, we know all about how they work internally. So we also know about the authority process. So the person that you're talking to probably doesn't have the ability to just give you the reduction that you're asking for. So many different steps at many different companies, depends on which one. So on the whole, we know what works and we know how long it takes. We know that sometimes it's going to take extra time because of the arguments that we're making, knowing that it has to go through that authority process, just many different variables that are involved. But we've got some pictures here of our Lien team, and that is a heart because they are the heart of Synergy. So I know with these presentations, we have a lot of repeat customers who are coming to listen and gain some additional insights, but we also have some brand new people who have maybe never heard from Synergy or what some of our insights are. So I always do like to cover the insider knowledge about these various recovery vendors. So the big ones are listed here. So that's Optum and Equian, who have now combined, which has caused all kinds of issues with trying to get things resolved. Also Conduent and the Rawlings Company. Many of these insurance carriers have internal subrogation units. So we see that a lot of times with Blue Cross Blue Shields in various states or with Humana. There are also defense law firms that basically act as a subrogation vendor, but they are much smaller, and it's usually attorneys that are handling those particular files. So one thing to know when you are facing off against one of these representatives of a subrogation company is that they are trained, highly trained, I would even say, and that is that they are trained to speak what it is that the company wants them to speak, and they know it pretty well. So it's almost completely ingrained in them by the time they start working files, and you probably will hear a lot of the same arguments over and over again because that's what they know to say, and they believe it. And so that's often the difficult part when you are talking to them and you're like, but you're saying it wrong. That's not the way it really is. It is not so black and white as you're trying to make it seem. But they truly believe that it is based on the way that they've been trained. Along with that, they often have form letters. So you might make an eloquent argument outlining all of the reasons why they should reduce or not have a lien at all in your particular case, and you just get a basic letter back that doesn't seem like it addresses anything. Also by design. So larger the company, the larger policy and procedures they have in place. And with that is these kind of form letters that they're supposed to send out that if it's an ERISA file and this gets said, then this is what you respond with. Talked on the previous slide about authority, that when you are talking to a particular representative that they might not have the ability to reduce on that particular lien, that they have to have it cleared by perhaps one person, perhaps multiple people. And so really the more information that you're able to give to them so that they can go then present it to somebody else is going to help you hopefully get things done faster and maybe for what you're actually looking for. Many of these representatives are incentivized by bonus, but also by reprimand. So lots of quality things are in place at these large companies, as they often are. But the dollar amount that they're able to get you to write a check for, they are often receiving some kind of bonus percentage off of that. Also, if they're not making all the arguments that the company wants them to make, there's a risk that they either get paid less, or they get less files, or they get less files that give them less money, like lots of different layers that are in operation at these subrogation vendors. And really, it's important to know that they handle all the different lien types. So Medicare is with CMS, but Medicare Advantage is with any one of these companies. Medicaid might be through your state department, but there are Medicaid MCOs that are with Aetna or Cigna, and again, handled by these kind of subrogation vendors. So it's really important to make sure that you clarify on the front end, what type of lien is this that I'm handling, because what type of lien definitely dictates their right of reimbursement. So this presentation is meant to be quick, and on each of these particular lien types, I could probably do a 45 to 60-minute presentation, so I'm going to try to just do some quick hits. ERISA is the biggest lien type that you probably see in your office. These are employer-based health plans, probably the health plan that you have through your firm. 65% of these plans are self-funded. And if it's self-funded, and if they can prove that it is self-funded, then they do have elevated rights based on the US Supreme Court decisions, which really points right back to their policy language. So on these plans, getting the policy language is one of the most important things that you have to do before you even start negotiating. And that is with a 1024 request. So 1024 is in the ERISA statute that basically says that a plan participant on one of these ERISA plans has the right to request plan documents from the plan administrator, which is the employer group. So definitely want to make sure that you are doing that if it is an ERISA plan, if they are asserting that it is an ERISA plan. FEBA are federal employee plans. So these are also employer-based, but this is for federal government. So important tip to note that the policy language for these plans often have discretion for if your injured party is not made whole or if your injured party has to pay for attorney fees. Difficulty is getting them to use that discretion. But if it is in that policy language, that's definitely one of your buttons to push. Military liens, liens with the VA or TRICARE. Important tip is to look at the hardships that your injured person has. Often they have a special care for the veteran who maybe is going to have some hardship because of the injury that they've sustained and because of the financial impact that it may have. So being able to present that argument and tell that story is really important on the military liens. For hospital and provider liens, you might have these under a letter of protection. Synergy doesn't really handle those when it's a letter of protection because that's your relationship with that individual provider. But if it's not under an LOP, then we definitely handle them. And there's a whole important distinction about lien versus debt. So the lien is attached to this settlement and the debt is attached to the person. So you are responsible for any hospital liens that may exist. And even after you take care of a lien or get a lien waived, there's still a possibility that the debt still exists for your client. So important distinctions there. We've got some other webinars about that important detail, but it's definitely something that the Synergy case specialist will be taking a special look at to see if it's a lien or a debt. Medicaid liens. So you might be dealing with the state agency or one of those individual subrogation vendors because it's an MCO that is handled by a private insurer. Each one of these Medicaid liens, you want to be looking at your individual state. We've got the Allborn decision, the more recent Gallardo decision that all plays a part. The result you're going to get will depend on whether you're talking to that agency or whether you're talking to one of the subrogation vendors. Oftentimes with subrogation vendors that are handling Medicaid or Medicare plans, they think that different rules apply to them. So getting through on that level is really the first step. Medicare that is handled through CMS, the most important things that you're going to be doing there is auditing those claims and making sure that they are actually related to the loss that you're representing that Medicare beneficiary for. Also, they're going to automatically apply that procurement cost reduction to their asserted reimbursement amount, and then that will be what the final demand is. Unfortunately, sometimes Medicare will take all of the remaining funds if their amount of claims paid is significantly more than the settlement. In that situation, they do give refunds. So if that's not something that you are doing in your office, certainly seek out Synergy because we can assist you with that. Medicare Advantage plans are handled by these subrogation vendors. They have the same rights as Medicare, but again, these subrogation vendors often think that they're different. So again, that's one of the first hurdles that you have to get over in order to begin negotiating, is to make sure that they're going to apply that procurement reduction that traditional Medicare has to apply. And finally, private insurance. So these could be employer-based plans. They could be marketplace plans. They could be through an insurance broker. But basically, these are fully insured plans that are going to go by state law. And each state has a different way that they handle subrogation and reimbursement. Some states specifically talk about attorney fee reductions, made whole reductions, what happens if there is comparative fault that is there, and other states don't talk about it at all. So really having an understanding of what your individual state how they look at those issues is an important start to how much of a reduction you're going to be able to get on these. And that is the end of my quick overview. I'm a little bit out of breath, so I'm going to go take a deep one, but hopefully you enjoy the rest of the summit. And if you have any questions for us regarding lien resolution, that is our general number. Feel free to reach out to us or your individual contact that you have at Synergy. We look forward to helping you.
Next up is Ilya Lerma of Trial Structure. Her presentation is entitled Advanced Witness Preparation, Help Your Personal Injury Client Tell Their Story. Ilya's presentation will help you prepare your client to be a compelling witness at deposition and trial using state-of-the-art neurological science developed from advanced therapeutic techniques. The techniques she will discuss will help your client tell the story of what happened so the jury sees, hears, and feels the depths of what the defendant did. Let me introduce Ilya. She's an outstanding trial lawyer practicing with her own firm, Phoenix-based law office of Ilya Lerma. Due to medical issues affecting a close family member, Ilya grew up around neurologists, neuropsychologists, and neurosurgeons, and even planned for medical school. Over the years, insidious brain injuries and concussions impacted her closest friends and relationships. And early in her practice, she became a voice for clients suffering these injuries. For more than 2 decades, Ilya unearthed the details of her clients' cases because she knew and understood where to look. She uncovered the evidence so that she could not only deliver the stories of their injuries, but their lives. Ilya, I'm turning it over to you for what I know is going to be a fascinating presentation.
Thanks, Jason, so much for that terrific introduction. Today, I get to talk about my favorite topic, that is advanced witness preparation. I am probably unlike 98% of plaintiff personal injury attorneys who have a little bit of a feeling of terror when it comes to prepping the difficult or reluctant witness. So ideally, some of these advanced witness techniques will facilitate better examinations from your clients and from difficult witnesses. So let me go ahead and share my screen. So as you indicated, I work with an organization called Trial Structure, and we work with plaintiff personal injury attorneys across the country, not only preparing their witnesses for deposition and trial, but also preparing their cases and litigation strategies from beginning to end. We do have an entire structure for trial. It looks a little bit like this, and then broken down into pieces. What we're going to be talking about is that box behind voir dire. If you are a student of trial structure, these types of techniques are going to be where we elicit details of the case for our opening statement and in preparation for our witnesses for trial. In order to have a great witness, there's 3 real cornerstones that I think are the most important. And that is that your witness come across as truthful, transparent, and consistent. And that's relatively easy to understand conceptually. It's very difficult to elicit on the stand in real time as your witness is facing the terror of cross-examination and worrying about details and what they're supposed to get out for the record. And it can be very, very challenging, even though we know that we want our witnesses to come across as very believable. Actually getting the witness to come across that way is difficult because it's a high pressure situation. And the brain shuts down. We're talking about the nervous system, we're talking about the limbic system, and their hearts may be racing, they're inside their heads a lot, thinking about details. And a lot of that interrupts the very basic precepts that we have about trustworthiness, about transparency. And so that's why just telling a witness, hey, just tell the truth, is really difficult because they can't always access the most truthful portions of their brain when they're talking about an event. If they're feeling stressed, if they're experiencing anxiety or depression, that's why these conditions really affect witnesses and their memory in the way that they do. So just telling your client, hey, just be truthful, that it doesn't really help them. So we've learned in the process of witness prep that getting a client to be able to relax as they head forward to their testimony is really, really a key component. So a lot of times I will deploy strategies like relaxation or meditation. I may even, for the right witness, recommend some grounding techniques, because it really helps to dissipate a lot of the nervous energy that clients have going into the process. And the earlier they start, the better the results tend to be. So always, always, always keep in foremost. I know a lot of attorneys tend to procrastinate. Witness prep is so important, and it's so much more compelling when your client has an opportunity to prepare and digest. A month before is fine. It's a heck of a lot better than a day or two before. So don't skimp on the time for witness prep. Your client will appreciate the opportunity to kind of practice and mentally and physically get ready for the stress that they feel. I probably don't have to spend too much time on this slide. We know a lot of the problems with witness testimony. Specifically, I like to highlight those that are emotionally flat, or sometimes those who are emotionally extreme. There are witnesses who it's like their one opportunity to finally come forward and give their version of events to plead their case, and they want to get it all out, and they tend, unfortunately, to come across as too emotional. And if there's a narrative on the other side that the client is malingering, or they're exaggerating or faking, those kinds of responses, even though they may be genuine to the client, they tend to feed the narrative of the other side. And so we want to be able to recognize what are the difficulties that we're going to have with this witness, so we really know where we need to prep them. You may have a client who comes across as defensive. They don't mean to. Here's a perfect example. I had a woman that I was preparing for. There was a woman I was preparing in Arizona for a colleague, and she had this tendency that whenever she was being cross-examined, and we were doing a mock cross-examination of her in order to prepare her, and she would do this, and she had this very, and she would kind of rock back and forth. She wasn't sitting in her chair, but she would rock, and she had her eye, and she just, the expression on her face just indicated a lot of disdain and dislike for the defense lawyer for obvious reasons, but she wasn't quite aware that she was making those faces and that she was coming across as defensive and somewhat unpleasant. So we actually worked on relaxing her facial muscles. I gave her a few techniques to try, and then we actually made it a little bit of a contraption that she had so that she could be aware of when she would do this. And so she had a much more relaxed demeanor when she actually came to testify, and it was much more compelling. So the point of that story is really, it's twofold. Number one, know what the problems are with your witness, and number two, understand that there's things that you can do once you bring it to the witness's attention that they are acting in a certain way. And video recording is a phenomenal tool that should not be underutilized. A witness who has to sit and look at a video of themselves as they're testifying, none of us like it. I almost never go back and watch my own recordings, except when I'm in trial. And I will video record my cross-examinations at times so that I can make sure that I'm in control of that emotional expression that may be escaping our conscious mind, because we may think we're being polite and responsive, but the video doesn't lie. And watching that, having your witness watch that, it's a very, very powerful reality check, and it shouldn't be underutilized. So I love to include this slide because this is exactly how your witness feels in terms of getting ready for their testimony. It's a big unknown rabbit hole, and a lot of times all you said is tell the truth, do your best, try not to testify inconsistent with your deposition, and it's simply not enough because of that anxiety and stress for the reason that we talked about. They're in conflict and they feel intimidated. It's a big black hole down there. So take the time to walk them through even the very simple basics, not just the rules. You know, we've got 6 hours in this jurisdiction. You can ask for a break, ask for clarity. Those are all important. But they also need to understand, how is my deposition going to be used, right? They just know they give a deposition testimony, then trial. Well, then you have to talk to them about, well, how is this testimony going to be used? How is it different from the testimony that I will be giving in trial? Why does the defense lawyer need this? And these steps are important for this next slide, because a lot of times the personal injury client doesn't understand what the litigation process does. All they know is they were injured, that it wasn't their fault, and somebody's supposed to be responsible for this. So they just know that they're supposed to kind of go and tell their stories and talk about their injuries. Their injuries from prior to this, their prior emotional state, prior anxiety and depression, the fact that they may not have had a good relationship with the decedent, they don't know exactly how all of those pieces fit. And they may go into a deposition with a different narrative, a different understanding than what you have, and certainly from what the defense lawyer has. So try to understand, and this is a good time to ask questions of your witness. You know, what do you think this is about? And it's an incredible gauge of where they are in the process, because a lot of times they simply don't understand. So before you start spilling what the case is about to you, take the time to find out what they think the case is about. And that will help you later, because if you can weave those two things together, it's a much more compelling position from the witness's perspective, because they're not just adopting what the lawyer thinks about the case. They have their own perception, their own idea about what the case is for them, weaved into the direction of the testimony. Sometimes this is easily done, but at times, and it's usually the difficult witness, that it's definitely not. So I do like to put a slide on the don'ts. Most of these you know very well, so I'm not going to go through them one at a time. I do want to cover the one that says, don't buy into their bull. And I started putting this in because some of my most difficult witnesses were lawyers. And what I found was they're very good at lawyers and very smart academics, professors, medical doctors. These witnesses, when getting ready for testimony, and then even after, they come up with a lot of excuses. And they don't mean to, but a lot of it is this intellectual protection of why they're not able to quite remember 100%, or why they're not able to get this technique like other witnesses might easily do. So they give you a lot of excuses, a lot of barriers to entry. And with those witnesses, don't accept it. You have to keep pushing and keep pushing. Get them on your side, certainly, because a lot of times they may end up in an adversarial posture to you, not recognizing that you're there to help them. But you definitely don't want to buy into their bull. Don't accept their excuses for why they're not putting in the practice and trying these techniques, because once they do buy in, then they're eager to learn. Most of us are eager to learn. Most of us were good students in school. Maybe not terrific students, but decent enough that we could pay attention and follow along. And that's really all we're asking for. So don't let them give you excuses as to why they can't deploy some of these techniques. And the other point that I would like to highlight on this slide is, don't ignore the trauma and emotional and psychological condition. And that goes for not just the subject of the litigation, the car crash or the medical malpractice. Of course, there's going to be emotional overlay and components that are weaved into the client's memory. But it also goes to their emotional condition before all of this. And a lot of people aren't great at dealing with trauma, identifying their emotions, speaking about their past episodes of trauma that may have to be worked through, even if you do not expect them to come in at trial because they're not relevant. That does not mean that the client should be deprived of an opportunity to process some of the things that have happened to them. So if they have big trust issues, say from something that happened to them as an adolescent, then, it's very likely that their trust issues are going to interplay with you. They may interplay with the consultant like me, who comes in to try to help them. And if you ignore it, it's only going to block the testimony that is really there. I have found that it doesn't take a lot. It takes targeted focus to be able to identify and work with some of those unprocessed feelings, but it doesn't take a lot. I'm not a therapist. I don't represent that I am at all here to help, from a psychological perspective, them process what they need to process with a professional, but certainly giving them a platform to be able to talk about some of the things that they have internalized and internalized deeply, and just giving them the opportunity, knowing where to spend that time really makes a difference in a witness, particularly those who have had a series of traumas, maybe this event like a series of sexual assaults, or a event of losing their mother to doctor's negligence 20 years before, and then a car crash on top of it. So do not ignore those emotional conditions and psychological conditions, because doing so is to your detriment. What you end up with is a fraction of the kind of witness that you could potentially have on the stand. I received the idea for this slide while preparing a TBI client who said that I know the information's in there. It's like, I know somebody asked me a question and I know, but this is what it feels like. It feels like I have no idea where it is, where to start. I know it's there, but I can't get to it. And that's really very common with a lot of these that I've indicated on the left. There are physical limitations, because there's intellectual, emotional, psychological to getting to that data. And sometimes you can't get to it. Sometimes, again, like with the TBI client. And so the preparation becomes, well, how do you deal with the memory holes? And we'll talk about that. But these other items like physical and social is a key one, because a lot of times you'll have male clients who are socialized to not complain, to not talk about their feelings, and they have a very, very difficult time expressing the loss. I worked once with a father who had lost his 19-year-old daughter to a medical mistake, and it was very, very tragic. And the ache that was palpable where he wanted to go was so difficult. And the lawyer that called me and wanted me to work, and that was really the pinnacle of my recognizing how deeply internal a lot of that emotional baggage can go, because it was very, very difficult. And so recognize there are differences between men and women. There's differences between social and cultural backgrounds in terms of how they can express. So recognize that, and that it may be a functional limitation, something you can't resolve, in which case you may want to think about bringing in somebody who is able to more readily deal with some of this, who has a lot more practice at it. So I love the great Yogi Berra. This is one of my favorites. You've got to be really careful if you don't know where you're going, because you might not get there. And I love that phrase because it takes me to this point, and that is that you need to know your case and you have to share it with the witness. You have to know the opposition's case and share it with the witness. They have to understand. Let's take a routine medical malpractice case, like there is such a thing, right? But in every instance of a medical malpractice case, there has to be some type of trusted relationship between the physician and the patient, right? And so the defense lawyer in a deposition may start going into, well, how long did the plaintiff know the doctor? How did they find them? And if the client doesn't understand that the relationship, the physician-patient relationship, is a key component of that, they won't spend any time thinking about it. So the deposition comes out rather flat and thin on details. Well, by the time we get to trial, maybe there's some additional details, but they have to know that the relationship between the physician and patient is important. It's important to us because of duty. And we assume those kinds of things all the time. I cannot tell you how many times you think your client has a good handle on what the case is about, and I can tell you they don't. A lot of times my working with the client is really helping them get a fundamental idea. And I love when the lawyers are in the prep. In fact, it's usually one of the conditions that I have. I don't want the lawyer bringing me in and just leaving me alone with their client. The lawyer should be there because we're building a relationship and working together. And I'm helping the lawyer and client communicate, sometimes in some places where they haven't touched yet or have been historically difficult for the plaintiff to get to, because believe it or not, plaintiff attorneys are not always great at listening and being able to see where their client is struggling. So if you do work with a witness consultant, I highly, highly urge you to not skip those sessions. Be present with your client. It's a huge trust building opportunity for you and the client, and you will see things in your client that you didn't know were there. I can't tell you the number of times that I have been called for a difficult client, you know, that guy who's kind of a jerk. Maybe he even lied or exaggerated. I had one that he had made up this very fantastic history as a war veteran. Well, it wasn't true, but of course the defense found out about it, and we had to navigate that. But I've been called in on those situations, and a lot of times it's a very superficial grasp of who your client is. And I'm going to tell one more just quick story. And I tell these stories not to give war stories, but more so that you can see that when you dig, you can draw these connections. we had a tax attorney who, she was brilliant, just absolutely brilliant. She'd had a photographic memory from the time that she was very young. And she had been involved in a crash. And it turned out that part of the reason she had gone into tax and estate planning was she had lost her father at a very young age and grew up in some very poverty-stricken circumstances. And it was very tragic. But what we learned in the process of deposition is not just that she lost the opportunity to engage as a tax and estate planner, but what it meant to her. In her mind, she had never really connected the fact that what happened with her own parent, who died and left them, unfortunately, nothing, and she was forced to grow up in these really poverty-stricken circumstances. The reason that she went into estate planning was she was sparing families from being able to have to, or sparing. The reason she went into tax and estate planning was because she was sparing families from suffering that same fate. She was able to prevent that same kind of thing from happening and prevent that slide into poverty. Well, when we prepared her testimony for trial, those pieces all fit together, because not only was she not able to do the job that she loved doing, she also felt like she'd had a loss of this connection to families that she was sparing from, future disaster. That was a great deal of pride and satisfaction and comfort, and the enjoyment of her life was helping families have these tax savings, have these future education plans, and she was no longer able to do that. So those stories, even going very far back, are really important to the client's overall portrait, right, in front of the jury, what they look like. It's a very holistic kind of thing. But you're never going to get those kinds of details if you won't spend time getting to know your client, getting to know their story, and getting past your fundamental maybe dislike or resistance towards them if they are abrasive. What you will find is that sometimes even the most abrasive witnesses have a reason that they are like this, and they feel unheard, they feel unrecognized, they feel unseen. And so a lot of times the fact that you're talking at them and not connecting with them and not asking questions of them in a way that they can connect to, unfortunately, that sort of feeds the narrative that they're isolated and that they're, on their own, and the lawyer's just there to collect his, 30 to 40%. So spend the time getting to know the witness, making sure that they understand both sides of the case. Before I leave this slide, I'd like to talk about one more thing. The opposition's case is really important. The client needs to understand how the defense is defending the case. How are they saying it's not our fault? How are they saying it's somebody else's fault? They're blaming somebody else. They may be blaming the plaintiff. And how they're saying it's not a big deal. What is the attack on damages? Are they saying it's pre-existing? Are they saying there's no causation? Are they saying they should have been better in 4 to 6 weeks? Make sure that the clients know and understand what the defenses are. They have a much better understanding of where their testimony is supposed to fit when they have an understanding of what the two sides of the case are about. Work with witnesses on their understanding of delivery and content. a lot of times, and I think it's because we're so used to dealing with transcripts that, we don't spend a lot of time on the delivery portion. We're just concerned about the content. But anymore, video depositions are the norm. I know plaintiff attorneys who use 2 and 3 cameras on witnesses. So the way things are said are just as important as what is said. So spend some time with your client working through some of what they're talking about. If they're relaying, for example, a conversation with the doctor, and they say something to the effect of, well, the doctor came out and, I was really worried. And, he said something to the effect of, the surgery had gone well, that there was a lot of blood, but he was just really going to have to wait and see. Oh, and he also said that, that my sister was probably going to be blind. That's a very powerful piece of testimony that's rendered very flat, and it's understandable because you're in a deposition room. There's not a lot of witnesses there. So if your client shows up and tells this really emotional story on the stand, and they play some portion of her deposition, those two are going to look incongruent. So you want to make sure that your client is treating the deposition like it is trial testimony. Spend the time, and we'll get to this in a few moments, allowing them to get into the experience of what they're testifying about. And they can say, well, the doctor came out and said, it doesn't look good. There was a lot of blood. The surgery did go really well, but it's going to be touch and go. We'll have to wait and see. And that kind, even though, you don't have a big shift, you don't have to have big emotionality coming from the witness. You're not asking them to be dramatists. You're not asking them to be thespians. You just want to spend the time getting them into that space, and the body will remember. This is probably, if you take away anything from today, this is the key thing that I would love for you to take away, and that is the body stores the emotion. It is in there. I have yet to meet a witness who couldn't access what was in here. Some of them took a lot more time than others, but the body does remember. The body does keep a score. The title of that book, the body keeps a score, and it stores a lot of information. There's new studies now that are coming out in terms of the relationship between the hippocampus and the amygdala, and it sort of explains why a lot of times your client seems like they have a terrible memory for such a significant event, right? Like car crash, maybe they described, I had a woman who said she felt like one of those metal beams fell on her car at the moment of impact. Well, that trauma and emotional memory, that's kind of interweaved together, sort of like that Gordian knot. And getting to it is possible, but it is difficult. So when you put your client back in that space by having them talk about the setting, what they see, what they hear, it becomes very visceral. And so don't skimp on the time that's necessary to do that. This is not something you can do in a day or two before their preparation. Oops, I skipped that slide. Timing and sequence matter. And I include this slide. It really has more to do with testimony at trial, but I include it because what a witness needs to learn is that they don't have to carry the water for the entire case. And I'll talk about this in one of the future slides, but they need to know they don't have to testify to everything, right? How guilty are we of sending in our witnesses into a deposition, and they think they got to carry the whole case? but they don't, and they need to understand that. So again, spend some time with them so that they understand. Their testimony, there's a whole host of casts of characters who are going to be coming into this trial and into this case. There's going to be before and after witnesses. There are going to be spouses. There are going to be treating doctors. There are going to be expert witnesses. So it takes the pressure. It really alleviates that pressure that's building up from having to, think they've got to remember everything. They don't. But let them know that, because they don't. They go into deposition and trial thinking, oh, I got to testify about everything, and I just don't know what it is. Think of how much more relaxed you were in school when the teacher would tell you, oh, I'm going to test you only on chapters 2 and 7 versus, any universe of the textbook, right? So spend the time with the witness, letting them know where they fit, where the most important functions of their testimony will be, and then sequence them too. If you have a weak witness, let's say somebody whose memory just doesn't come back, or usually what we see is the very argumentative or defensive witness, think of building as much of the case over them. In other words, tell more of their story through witnesses who are more compelling, like their spouse who has to live with them, right? We see this all the time in brain injury. A lawyer will call me and he's like, God, my client just, he's argumentative and he's defensive and blow up at me because I'm trying to help him. Well, part of that is the brain injury, but it's also very navigable if you put on, say, the spouse first, who can talk about the transition, right? The loving, attentive husband that he was before, and then the next thing you know, he's throwing the shoe at the smoke detector and smashing it into pieces because he's come unglued and he can't figure out how to change the battery. So by sequencing your order of witnesses correctly, you can have much more impact and deal ahead of time with some of what the jury might see. So in the example I just gave, let's say that the plaintiff blows up on the stand during cross. Well, the jury already knows that he's prone to lose his temper as part of the brain injury because you set it up through the doctor and you set it up with the spouse. And so a lot of times your own anxiety as the lawyer gets dialed down, and it's hard to put a price on that. Stories are far more interesting to jurors than a list of character traits. You want to say that a client was funny, or they were a good dad, or they were really smart. The things you say are way better if they're interweaved in a story. So a great example might be somebody who's athletic, and you tell a story about them rock climbing. A person who is funny, and a joke that they played on someone. I worked with a gentleman who had permanent nerve damage in his arm, but he told this wonderful story about, before his injury, these pickup games that he would have with his 45-year-old buddies, and they're kind of smack talking on the court, passing the ball back and forth. And they're like, oh, you're just getting too old for this, and the dialogue was so, it was engaging. I still have the images of not only him, but also his friends that were conjured up. And that's a far more interesting way to have clients talk about their stories, keep the jury engaged, but also it's releasing those same chemicals in their own mind of where they were. So that client, even though he was in tremendous pain, couldn't really even move his arm an inch or two, without having experienced like shocking pains, like lightning going down his arm. When he told that story, his face kind of lit up, and you could see just the memory of being with his buddies and on the court. You know, it was so powerful. And just that little smile, because the body was releasing that memory. It was flooding him with the same neurochemical cascade that we experience in the moment that it happens. And so you're getting a smaller dose of that. And that goes to those very things we were talking about at the beginning of the presentation, the credibility, right? The trustworthiness, because it's in them and they've finally let it go, because they're not talking about it from up here. They're literally beginning to re-experience that moment in live and real time. And so instead of ending up with a sort of flat memory, so memory is like on a timeline, and they're trying to go back, you know, and remember what happened. But if you put them back in that space, you ask him what the gym smells like, right? You ask him to kind of put that sensation of the ball between his hands and hear the voices of his friends. And it opens up into this really beautiful holographic space. And this is how people remember. This is that connection between the amygdala and the hippocampus. Well, this is where, when we have memory gaps, and we have witnesses who are struggling with remembering, when you bring those two things together, again, the memory and the experience, that's when all the details come out. I can't tell you the number of times I've had lawyers say, God, you know, I've talked to him about this crash, you know, 15 times. I never heard that before. And it's because, you know, I'm able to work with the witnesses to be able to get that dimensional aspect out and get out the details. And again, that's just huge for credibility. A couple of things I'd like to say about, let me go back to this slide very quickly. So what I was saying earlier is memory is kind of linear, right? And we go back and try to retrieve. When you go for an experience, what happens is that linear line goes away, and the person is experiencing in kind of live in real time what happened, the conversations that they had, the people yelling, the smell. I mean, imagine people talking about something as traumatic as 9/11, right? We can all go back in time and remember where we were. People who were down at ground zero, they can talk about that and say, you know, there was all this smoke and people were screaming, and, you know, I had ash and building and dust all over me. Or, you know, they get into the visceral, they get into the visceral experience of seeing the smoke coming at them, really hearing the sounds of people yelling and the absolute chaos around them. And that's very different from this linear line. The linear memory is where witnesses get in trouble. And this is witnesses of both sides, because they're trying to go back and remember, but our memory is very imperfect. And so when they go back, a lot of times the mind doesn't like gaps. It likes to fill in spaces, but you may not have an actual memory of the specific thing that maybe is the subject of cross. And the witness becomes tempted to try to retrieve every detail. And by focusing on the experiential memories, they become more comfortable, say on cross-examination, when the defense lawyer says, well, isn't it true that, you know, that you had this conversation with the doctor at the hospital? Then they pause, they go back and they try to draw that experience back to them. And they may have the memory of the physician conversation, in which case they can testify to that. But if they don't, they begin to, instead of searching for that, oh yeah, I must have because then this happened, and filling those details in, not because they're lying or exaggerating. It's just the way the memory works. But when you explain that to them and they don't feel the pressure of having to have a memory for every single question, then they become very comfortable saying, I'm sorry, I don't have a memory of that. And the defense lawyer says, well, we've got this form that says, the doctor had a conversation with you. And the witness says, well, maybe I just don't remember. It's possible I just don't remember. Right. And so they're not defensive. They're not getting engaged and getting triggered by the defense lawyer that way, because they're not searching along that timeline for what they know must have happened. So they have to give a response. Instead, you teach them, focus on the images, focus on what you heard, what you smelled. And then they become comfortable saying, yeah, I don't have a memory of that. And that it works really well. Again, they're being truthful and consistent in terms of their testimony. So these are a couple of last minute tips that I always have for lawyers when preparing witnesses. You're asking your client to talk about deep, emotional, painful, awful things. Be willing to share, be willing to be vulnerable, maybe with your own story, maybe with something that you've experienced in your past. You're building trust. And if you want to have compelling deposition testimony, if you want to have cross-examination that survives, or a witness that survives cross-examination, and you want to own that courtroom during direct examination, you need to learn how to make yourself vulnerable to the same things you're asking your client to be vulnerable about. It's really, really important that they feel like you are there with them. Along that same train of thought, pay attention. Your client is giving you these deep, personal, embarrassing, sometimes clients have to talk about loss of bowel function or loss of intimacy with their spouses. They're in these scars that they have. They're embarrassed and shy and vulnerable, and you are taking down notes. Put your pen down and be with them. You can go back and watch the testimony later. You can read the transcript of the deposition later. Be with them. Hold that space for them. Pay full attention and let their testimony come alive. You will be inspired to connect with powerful, powerful moments of their testimony that won't come to you when you're busy writing things down or thinking of your next question if it's on direct exam. And this is, I see this more in trial because I work as a trial consultant and I've made it my job to watch a lot of trials. This happens more with plaintiff personal injury attorneys when they're witnesses. I think they're uncomfortable. And so they get uncomfortable that they might get triggered. They don't want to cry in front of the jury themselves or get too emotional. So they start writing things down. Don't be there with your witness, honor their emotion. And that's not the time to go to your checklist. I'm a big believer that you should have a checklist anyway, but that's a topic for another time. Help your witness talk about pain by finding out if there's an image that they can connect. A lot of times clients will say, oh, I have this ache, I have this pain. Sometimes they'll go so far as to say it's heavy, it feels like this heaviness. Well, if you had to paint a picture of it, what does it look like? This heavy thing? Sometimes you'll get bolder. One time I got this contraption. It was like a metal contraption that had the arms that would, like, you'd crank it and the arms would just squeeze the vise, right? And she said it just always felt like it was always cranked. And then sometimes it would crank even tighter. Those are powerful images. And if they come from the client, you're not embedding them. They're coming from the client. They have a good descriptor, and that's very, very useful when you're trying to talk about something that's so general as pain and making it very specific to your witness. I do like to ask about metaphors for pain. Those are rare, but they certainly do come in. These are my final parting thoughts for working with witnesses. Modeling good behavior can be helpful for the right witness. Definitely video your witness, especially if you're having a difficult time with them. They sometimes need to see themselves. They need to see that they're talking a lot, that they're not really answering the question. I usually recommend spending some time or giving the witness some time before they watch the video. So after they've just given you a sample testimony or series of answers to some deposition questions, showing them the video right then and there isn't usually that helpful. It sometimes can be counterproductive because the witness will feel criticized. So what I usually suggest is video them as you're doing a mock direct examination. Send them the video later that evening or the next day, and then give them 2 or 3 days to digest it, so that when you come back in another few days, they're a little more prepared for the critique. It's hard for all of us to accept criticism. Witnesses are no different. Usually parents are pretty good at accepting criticism because they've been broken in by their kids for so long. But the video is a great underutilized tool. Of course, focus groups. Those are fantastic. I also assign homework to witnesses. Sometimes it is doing those meditations. Sometimes there's visualization techniques that I will recommend. I have also suggested, grounding or certain walks. I've recommended to yoga to certain clients because I'm a little bit of a hippie at heart. But those things do work. Again, they sort of break up the stored emotional energy of the body and can be very, very useful relaxation tools that I think are also underutilized. And repeat. I mean, 1 session, 2 sessions, not enough. Break it up into at least 3 or 4 sessions with your witness. It will make the difference when you do spend time with them. One of the things, before I leave that last point about spending time with your witness, I've had a lot of time in my own practice, and as well as a consultant doing both structure consulting and witness prep consulting, to really observe a lot of different attorneys, to really develop techniques that are effective and that they do work. And let me just say, this is only scratching the surface. If you deploy these strategies, no matter what, your witnesses are going to improve. But we are very careful about the defense bar misusing some of the things that we teach, some of the things that where we work with witnesses. And so I just want to be clear that this is by no means a deep dive into witness prep. There are countless more tools and techniques and strategies that we have cultivated that are different than anything else that's out there. We are not psychodramatists. Actually, Alejandro, the founder of Trial Structure, is a former instructor for the Trial Lawyer College, but that was, a long time ago, and those aren't. Oh well, let me try to do this. Let me see. I have to be careful about saying that. Let me try that again. So ideally, I hope that these strategies will come to you very easily. I can almost guarantee that if you start using these strategies, your witness preparations will absolutely improve. These are tried and true techniques, but I would like to be clear that they are by no means exhaustive. Our witness prep that we utilize in trial structure is unlike anything else that I've ever seen, anything I've ever been a part of. And I can tell you from personal experience that not only do I get phenomenal reviews from attorneys, but also their witnesses that are, sometimes shared on my website, of the experience of feeling prepared and what that does for them. So I can't stress enough how important it is for you to not only look into these strategies, but also really be bold. Think about hiring a consultant, and take that with a grain of salt, because I am one, but there is so much more finesse, so much more technique, so much more that can be gleaned from a in-person or a witness prep by Zoom, when you have a professional who's dealt with a myriad of things. And I've gone from everything from schizophrenia, bipolar, anxiety, depression, PTSD, TBI, and that vast experience allows me an opportunity to see things that even really great, very seasoned, experienced lawyers don't always get to have a pulse on. So be bold and think about hiring consultants for the right case, so that you can really see the dimensional aspect of witness prep, because the reward of having a plaintiff give their testimony at trial in a compelling way it's indescribable. And I can say that I had a jury trial here in Arizona in federal district court, and the lawyer for Johnson & Johnson actually came up afterwards and said that was, an incredible direct examination. And we've had that experience a number of times. So when you can get those kinds of responses from seasoned trial lawyers, you know something's working. So on that note, please feel free to reach out to us, booking a consult or getting more information about structure or about witness prep. The contact information is there. You can reach out to Brad, our executive director, who's fantastic. And I just wanted to thank Synergy and Jason for having me on and getting to talk about this most amazing topic. Thanks so much.
Rasa Fumagalli from Synergy is our next presenter. Her presentation will focus on quantifying future medical damages and Medicare compliance. Rasa Fumagalli is an Illinois licensed attorney and the director of MSP compliance services for Synergy. Rasa and her team provide plaintiff attorneys with initial consultations to address any Medicare secondary payer compliance issues that may arise in connection with their clients' personal injury or workers' compensation cases. Prior to joining Synergy, Rasa worked as a workers' compensation insurance defense attorney in the Chicago area. She has spent the last 10 years focusing her practice on Medicare secondary payer compliance issues. As the former director and vice president of MSP compliance for a national vendor, she has extensive experience in working with parties to effectuate settlements while addressing Medicare's interests in a reasonable manner. Rasa's knowledge, experience, and passion for navigating the intricacies of the Medicare Secondary Payer Act, supporting regulations, and CMS allow her to provide valuable and pragmatic guidance in all stages of settlement discussions. Rasa, the floor is all yours to dazzle us with your expertise related to medical cost projections and Medicare compliance.
Hello, my name is Rasa Fumagalli. I'm an attorney and I'm the Director of Medicare Compliance here at Synergy Settlement Services. I'd like to tell you a little bit about Synergy's medical cost projection. Medical cost projection helps you quantify the future injury-related care when you are making a settlement demand in your case or negotiating a settlement. It's basically a cost projection of the future injury-related care and medical expenses that the injury victim is likely to incur in the future. The projections are intended to help you build damages they project for the worst case scenarios based on the information that you provide us, the medical records, and the standards of care guidelines for a particular injury. It is a report that you can attach to your initial settlement demand. It provides weight and credibility to your demand, and it helps the defense attorney actually get settlement authority much more easily from the adjuster than in a situation where you just make a demand without any supporting proof. It's also a great way to help you bridge the gap between an offer that you received and what your counter demand is. So let me tell you a little bit more about how the medical cost projection is actually prepared. It's prepared by a certified life care planner within our office. It is, as I mentioned, based on information that you, the attorney, provide. If you do not have causation opinions at the time you're requesting the medical cost projection, we can work around that and we can include the treatment for the condition that you are claiming. Regular turnaround time is 10 business days. The clock begins to run from the day that we receive all of the information. Unlike a life care plan that can be many, many thousands of dollars and take months to prepare, our report costs $2,500 and is a valuable tool for helping you maximize your recovery on a case. So, as I mentioned, you can use this tool, this medical cost projection, when you are making your initial demand. You can use it in pre-suit mediation, early stage litigation, and it makes a lot more sense in the majority of cases. So let me go over some of the examples of these successes that our clients have had with the medical cost projection. As you can see, there was a California auto accident case. Pre-medical cost projection offer was $30,000. After the medical cost projection was provided to the defense, the offer increased by $40,000 and the case settled for $70,000. Medical cost projection was also used in an Alabama motorcycle accident case. The pre-medical cost projection offer was $900,000. The post-medical cost projection offer and the case settled for $1,050,000 for a gross increase of $150,000. Now, the medical cost projection can also be used for catastrophic cases. In the Georgia medical malpractice case, there was a pre-medical cost projection offer of $1 million. The case ended up settling for $2.1 million after the medical cost projection was provided. This is an increase of $1.1 million. Contact Synergy to learn more about our medical cost projection. We are so confident that the medical cost projection will be beneficial for you that we have a risk-free guarantee. We look forward to discussing the medical cost projection with you. Thank you. Now that we've taken a look at medical cost projections, let's talk about Medicare secondary payer compliance issues when your injury victim is on Medicare or is likely to be on Medicare in the near future. Although you have this medical cost projection that is projecting future damages based on the injuries which you are alleging, this medical cost projection is not separating treatment based on what is Medicare covered, what is not Medicare covered. For those of you who may not be all that familiar with the Medicare Secondary Payer Compliance Act, I'm just going to briefly touch upon it. Basically, Medicare becomes a payer of last resort when payment has been made or is reasonably expected to be made under workers' comp law or a plan of the United States, under an automobile or liability insurance plan, or under no-fault insurance. What this means is that Medicare is precluded from making payment when payment is reasonably expected to be made or has been made under these plans. And when I'm talking about payment, I'm talking about a settlement, which is considered to be a payment in the eyes of Medicare. The exception to this is that when payment is not reasonably expected to be made within 120 days of when because the settlement is intended to compensate the injury victim for many different buckets of damages. A Medicare set-aside is only going to include injury-related Medicare covered treatment that is reasonably likely to occur. Once you have this figure, and you can think of it as a settlement tool that helps you support how much of this settlement is being carved out for future injury-related care. So once you have this Medicare set-aside number, there's a secondary analysis that takes place that looks at the ratio between the total potential case value and what all of the damages are worth in this case if you prevailed on all issues, and your client's net settlement after attorney's fees and costs are deducted. That ratio is then applied to the Medicare set-aside to come up with the lowest defensible amount that your client should carve out from the settlement and use for injury-related Medicare covered treatment before Medicare is billed for these services. So Medicare set-aside is going to include injury-related Medicare covered treatment, injury-related Medicare covered drugs. It is based on treating physician recommendations. It is based on evidence-based medicine guidelines. The treatment is projected at the usual and customary rate in a liability or no fault case. In a workers' comp case, it's going to be projected based on the workers' compensation fee schedule. Drugs are priced based on the lowest available internet schedule pricing, or in a workers' comp case, via Redbook. So we recommend that you start early by identifying your Medicare beneficiaries in your cases. It is much better that you, the attorney, take a proactive approach and control the Medicare secondary payer compliance process. We recommend that you never rely on your opposing expert's opinion when it comes to the need to set aside a specific amount from the settlement for future medical. You should make sure your client is informed and educated about the potential impact of the Medicare Secondary Payer Act on their settlement. We recommend that you retain your own MSP experts to protect you and your clients. Go on the offensive when it comes to Medicare conditional payments with liens under Medicare Part C and Part D. And most importantly, you must document your file. Thank you.
Our second to last speaker today is Jamie Holland of Trial Structure. His presentation is entitled Realities of Trial Work, How It Works in Jurisdictions like Florida. Let me briefly introduce you to Jamie. He is a phenomenally accomplished trial lawyer, bringing nearly 3 decades of trial experience to Holland Law Firm. He's a nationally board certified trial attorney who takes a compassionate approach to his cases. His goal is to help clients and make the best of difficult situations and serve as their trusted legal advocate during and after their cases. When he's not representing clients, Jamie can be found coaching trial advocates and teaching CLEs. Holland's exemplary work and his dedication to ensuring justice for his clients has landed him multiple accolades and recognition. Jamie, turning it over to you to share your trial structure wisdom.
Thanks, Jason. Listen, here's what I'd like to do today. I'd like to talk to you about getting to trial, particularly in a state like Florida, which getting to trial seems to be much more difficult. Let me share some thoughts with you. Let me go to let's see if I can find it. There we go. There it is. All right, there we go. I'm hoping everybody can see my screen. And here's what I wanted to talk to you about is if you're going to prepare and take a case to trial, one of the things you strongly need to consider is the client at the front end. In other words, what are you going to be doing? Will the client be able to take the case all the way to trial? And how are you going to get it there? And let me just go to one other. And here's what I mean by that. If you were going to take a case to trial and the client comes in your office and wants to hire you, and you think it's a good case and it's worthy to go to trial, what's the first thing you better do? Well, the first thing you better do is you're going to have to investigate your client. And that means run social media searches on them. That means run claim searches on them, run DMV records on them, and get all the information you can, because purposefully or not, clients are not always square with their lawyers. And why I say purposefully or not, I represent a lot of traumatic brain injury clients. And traumatic brain injury clients are among the most difficult to get a good history out of. It's not because they're trying to intentionally lie to me. It just comes with the territory. The other reason you better investigate liability early is because of House Bill 837. Florida just became a different state. It went from pure comparative, where any percentage of negligence will give you that percentage of recovery of damages, to a modified comparative, which 51% on your client and you're done. 51% or greater on the defendant and you're still alive and you're going to get damages for your client. But if you can't fairly confidently cross that 51% threshold, don't take the case to trial, because you're not going to like the result. And finally, manage expectations. One of the things that I think is our job as lawyers to tell clients the brutal truth. Tell them where the warts are in their case. Tell them what their personal warts are. I mean, do it in a caring, compassionate way, but they deserve the truth to know where their problems are and where they're going to get likely dinged by a jury. Because if you don't talk to them about it up front, it's going to be very difficult to do it right in the course of trial, or even worse, when they see it right in the course of trial. I also wanted to talk to you about disclosures. In Florida, for example, we are moving closer and closer to a federal court system. Now, judges don't necessarily have the staff to make it a federal court system, but the demand of the Florida Supreme Court seems to be taking us in that direction. So what does that mean? Well, expert disclosures. We can't just get away with disclosing the expert in a vague statement of the topic he's going to be talking to us about. We're going to have to work closer and closer to a full disclosure, almost like you do with a Rule 26 expert report in federal court. And that's going to mean it's going to take a lot more time. It's going to take a lot more work, and it's going to require more time to put all of that on paper earlier than we're used to. The other thing is key witnesses. Part of sitting down and doing a very thorough client interview is you're going to learn the key witnesses. Who are the key before and after witnesses? Who are the ones that can tell the story of the event? Who can tell it from the cleanest perspective, where they're not going to get hammered on cross-examination? Find out who those folks are and talk to them earlier when their memories are still good. And finally, exhibits. Exhibits and impeachment evidence. We're going to have to start making those lists earlier, finalizing those lists earlier, because how many times have you gone to trial and said, oh, I wish we had this exhibit. I wish we had that exhibit. You're going to need to get them all in, get them disclosed on the exhibit list, and get it all in evidence earlier, because judges, particularly with the COVID pace of trial, are becoming less and less tolerant of people being late on disclosures. Also, start doing your research. Start doing a very, very deep dive. What do I mean by that? Well, know your judge. You know, when I was an early practicing lawyer, I rarely did research on the judge. I assumed one judge was going to be about the same as the other, and I didn't do as well for my clients. Some judges have a certain approach that they appreciate. Some judges have special courtroom rules that you better follow, and you need to know them going in. Also, try to understand how the judge thinks. What are the arguments that are going to best reach this judge? Where did they go to school? What was their area of practice before they became a judge? Those are some things that you can help frame your motions to make them most receptive to the audience you've got, which is the judge. Do the research on the defense lawyer. Try to find an opening, try to find a closing, try to find a voir dire they've done. The reason is particularly as defense lawyers get busier and busier, they tend to go back to the same, well, bag of tricks. And they'll use the same statements and phrases in opening, same statements and phrases in closing, and they'll ask the same questions on voir dire. Well, if you can find their favorite questions and take them from them and ask them first, it puts you in the advantage. If you can project to a jury what their standard lines are and use them first, well, you're going to seem exceedingly prepared, potentially clairvoyant. And it really, really helps. Finally, do your research on the voir dire and do social media research. And you can ask, well, how do you do that? Well, you can hire people to do it. I think Jury X is one that does it out of North Carolina. Alex Alvarez has a program called Momus, which helps you do it. But some of the best jury social media research I've seen done is done by in-house, by lawyers and their staff who are working back at the office, pounding down in social media, LinkedIn, Facebook, Instagram, trying to find out all they can on social media about jurors. It really, really helps. And if you want to, go watch a seminar by a lawyer called John Ustall out of Fort Lauderdale. He does about the best job I know of anybody doing social media screening on the potential jurors that may sit on his case. I have a theater and film background. I was a professional actor before I became a lawyer. So what does that mean? It means I view every trial a lot like a theater production. What are the scenes I want to create? Who are the people I want to appear in those scenes? What's the dialogue between the people? And the reason is I try to make it as interesting a trial as possible for the jury who are giving up a week or 2 weeks of their time. And candidly, don't want to be bored. If you bore them, they're going to be working on their grocery list, but they're not going to be paying attention. Also consider this. Use technology to your advantage. What I mean by that is don't be afraid to the same technology that lets you take a witness's deposition. Don't be afraid to Zoom a witness in. In Florida, you've got to do a notice of doing it. And I also advise you to get consent of the other side so that you can swear the witness in remotely, because otherwise you have to put a notary public where they are in order to Zoom them in. But check out their background beforehand. Check out to make sure their lighting is decent. Check out to make sure that you're going to do as well in presenting by Zoom as you would putting them live. Now, why do I say this? If you Zoom a witness in, it's going to give you more flexibility. It's going to allow you to move along much faster. And it's going to give you more flexibility with the witness's schedule. I had a trial over on the West Coast last year where we Zoomed a witness in from a port beside the Danube because his river cruise didn't have very good internet. So he got off at a port, did the testimony by Zoom, took a taxi to the next stop, and got back on the boat. And that was a feat of technology. But you also need to, if you're going to do Zoom, make sure your technology works in the courtroom and make sure the witness can see the jury by your setup so that they can get the feedback as to what's working and what's not working in front of a jury. Also consider, I think as the pace of trial picks up in Florida and it becomes more and more difficult to schedule doctors, particularly treating doctors, what you're going to see is it's going to go much more like other jurisdictions I practice in, like Georgia. Having a treating doctor live is a rare occasion because otherwise you're going to have to pay them multiple times as the trial sets come up and you never know when you're going to go to trial. So everybody's basically got their treating doctors by video and in the bag. And you can do that and make them interesting just as you would in a live trial, but you've got to get your exhibits ready. You've got to get your demonstratives prepared ahead of time. You've got to use technology and PowerPoints and things to make it an exciting or trial testimony and more than just a talking head. Finally, live witnesses. Your live witnesses are the most important witnesses you can have in a courtroom. Make sure they're prepared, make sure they're prepared for what's coming at them, and make sure that they're emotionally prepared. Because if they are not emotionally checked in and present as they testify, the jury's not going to believe them. And you've got to get, if you don't know how to prep a witness, get a professional witness prepper in to prep your witnesses, and also teach you how they do what they do. Because it's an amazing difference when your witness is prepared emotionally and psychologically to take the stand. I want to talk to you. You picked your jury. They're sitting in the box. You have your audience. How are you going to try your case? Well, you better figure out who you're going to call as your first witness, because they better be relatively clean. In other words, the defense is not going to tear them up. They're not going to shove their theory of the case down through your witness. And the witness is going to be able to tell a cohesive through-line story that's going to give a jury a good idea of the case that's coming in. Also, what are the dialogues? Dialogue and two people speaking is a great talent used by comedians. It's used in movies. And guess where it's not always used? In the courtroom. It should be, because it embeds information more quickly than otherwise, and it allows you to control the tone and the emotion of the information, which is a lot better than just flat data. The other thing is, be prepared to use as many demonstrative evidence as you can. Now, why do I say use demonstrative? Well, there's an old adage in acting. If you can't act, get a prop. And one of the failures I see in witnesses and lawyers is their body language doesn't always help them. In fact, it's often telling a jury something completely opposite from what their voice and their words are. Well, if you get a prop, for whatever reason, holding something in somebody's hands seems to calm them down, seems to make for a better advocacy and a better show. And it just makes it a more dynamic presentation. And it keeps you from doing the cardinal sin of trial work, which is boring the jury. Also, your visuals. A friend of mine started changing the way he was doing trials years ago, and we started talking about it. And he started saying, well, I'm going to storyboard my case. Well, I drilled down on that because storyboarding is typically a process that's used in filmmaking, where you start developing the images that an audience is going to see. And that's really, before the scenes are ever shot, the case is storyboarded, or the film is storyboarded, so that the director knows what are the next images that are going to be progressed in a case. Well, he started using that technique in his trial work, and he became much more successful, but because he controlled not only the information of the case, but also the look and the embedded story in the case. Speaking of embedded story, if you don't figure out the drama in your case, you're probably not going to win. And what do I mean by the drama? Where's the conflict? Is it a betrayal that your client has faced? Is it behavior which generates one of the core survival emotions or reactions of disgust? Is it that's where the drama is? Or is the drama fear? Is it fear generated in the audience because they're concerned about what might happen to them? I mean, you've got trial folks that are based solely on generating this fear, and sometimes that's a successful strategy. Not always, but sometimes it's a successful strategy. But it comes from knowing the conflict in your case and knowing how a jury's going to react to it. And if you want to know how a jury's going to react, it's probably not going to be the way you think they're going to react. Now, what do I mean by that? Well, what I mean by that is you're going to have to focus group the case. You're going to have to get the case, the stories, the evidence in front of a jury so they can decide, is this going to be a case that they're going to do something with and that moves them to bring your client justice. Now, speaking of that, I often ask when I co-counsel cases, what's your target? What are you looking for? What's the number you want a jury to give? And ironically, the most common answer was, I don't know. I thought that's what I hired you for. Well, you need to know early on what your target with the case is. What do you think a jury will do with it? What's your target in terms of money? Are you trying a multi-million-dollar case? Are you trying a case that's just worth a couple $100,000? But you need to know that. And the reason you need to know it is you need to know where the damages are. And the easy ones are the medical bills and the earning capacity. Although I will tell you, in the current realm of Florida, given House Bill 837, consider dropping medical bills. Consider not even making it a feature of your case. Obviously, your client still owes the medical bills, and he's going to have to pay it out of pain and suffering. But if you don't take all the credibility and the coding hits and all of the hits that you may take with the special damages, you may be better off just leaving them out. Also, earnings and earning capacity. That can be a big part of the case. I do a lot of railroad work, and in Federal Employers Liability Act cases, earnings and earnings capacity are usually some of the biggest components of the case, particularly when you've got railroad engineers that are making, hundreds of thousands of dollars a year, and they're still have 10 years left in their work life, and a back injury is taking them out of that work. Now, the other place you really need to drill down on damages, and I've got some good friends who we've had some discussions with on how the big verdicts are made. Well, oftentimes they're made by anger in the jury box when the other side gets caught in a lie and the jury gets angry, and that's fed through in compensation. But oftentimes it's comes by forethought and preparation and not lumping all of your damages in together. When I ask students all the time, what are you talking about when you talk about general damages? Well, the most common answer I get is, oh, that's pain and suffering. Really? Is it? Go read the jury charge, because it's not just pain and suffering. It's pain and suffering. It's disability or physical impairment. It's disfigurement. It's mental anguish. It's inconvenience. It's loss of capacity for enjoyment of life. Every one of those is a single item of damages. And if you don't treat them as single items and talk about how many hours a day the patient suffers this item, what's it worth each hour, and what's that look like over a lifetime? When you see the big general damages verdicts that, the Keith Mitnicks, the Rick Blocks, the John Romanos get, where they get them is from breaking up and breaking down this area of damages and understanding that they have evidence to back up every item, and understanding that they have data so that they can walk a jury through in closing argument why the general damages of the case are worth hundreds of thousands of dollars or potentially millions of dollars, because they're going to be with the client for the rest of their life. They bother them so many hours a day, and that number per hour is a significant number. I have been asked to talk to you about trial work in Florida, and 30 minutes is way too short for this topic. It takes, I'm CLE chair for the FGA. We probably spend in any given year at least 120 hours of CLE. Actually, if you add workforce seminar into it, it's probably 200 hours devoted to this topic and this topic alone. So condensing it into 30 minutes is not really possible. But let me talk to you about how you can up your skills and improve your game. And that is simply by finding your mentors. I'm happy to be a mentor. It's one of the things that I do. It's one of the things that leads to so many co-counsel relationships, because co-counsel and I just want to learn from each other. And we do it by preparing and trying a case together. But who are my mentors, my go-to crew, when I have a question I want to ask them at 2 a.m. in the morning before closing? When I have a question, I want to ask them about how do I approach my opening. When I have a question about them, will this voir dire question work or will it not? Well, aside from the stalwarts of Florida, like John Romano, I also go to people like Brett Turnbull, like Kyle Sherman, like, Ilya Lerma, like Chuck Bennett. These are the folks that I've developed a rapport with and a connection with, and they know they can call me at any hour at any time, and I'll help them by giving them a sounding board to bounce basically their questions off of. I also can reach out to them and have them look at an opening statement, tell me what they think, tell me where my mistakes are, tell me what I can correct, and give me an idea what I'm doing right. And I've been doing this over 30 years. And the day I stop learning is the day I probably should stop practicing. Thank you very much. That's all that I've got. Thank you so much to Synergy. Thanks to Jason. And I really appreciate the opportunity to come and talk with you and share with you. If you have any questions, my email's on the slide. It's Jamie, Jamie, at Holland, HOLLAND.law. Thank you.
Our last speaker today is Dan Alvarez. Dan is one of my business partners at Synergy and is a former trial lawyer himself. Dan's position is Chief Revenue Officer with Synergy. Dan works nationally consulting plaintiff attorneys and their clients on the efficient resolution of catastrophic personal injury cases. Dan has a unique background in the industry, having worked for several years as a trial attorney. It was during this time that he developed a passion for assisting clients with a unique set of challenges that only begin as their lawsuit is resolved. Dan graduated from Florida State University, go Noles, with both his undergraduate degree and law degree. After law school, he began work as an assistant state attorney in Hillsborough County, where he tried over 60 jury trials. After 3 years as a prosecutor, he worked as a trial lawyer at Wilkes & McHugh in Tampa. Dan is going to talk about how to leverage Synergy services to make your law firm more profitable and efficient. Dan, the floor is yours.
I hope you've enjoyed today's program. My name is Dan Alvarez. I'm one of the founders and partners in Synergy Settlement Services. Grateful for your time. Just want to share with you some of the exciting ways to partner with Synergy, and we hope we can get a chance to earn your business and be a resource to your law firm and the families that you fight for. Some of our most recent changes first is our Connection platform. Our Connection platform is a portal that gives you and your team members real-time 24/7 access to all of your cases. You can see lien balances, updates. You can also upload information. You can intake new cases, and you can even chat message function with our team to just have real easy communication that allows you to focus on what you do best. We've also been working with our partners across the country on some case management software integration. So if you'd like to explore that option, please reach out to Synergy today. We've successfully got a number of our partner firms that are now able to hire us at the click of a button, and we're super proud of that efficiency. Love the chance to earn the right to be your partner, whether it comes to lien resolution, Medicare secondary payer compliance, or our new medical cost projections, which continue to kind of explode around the country this year in both their performance and results. We're seeing exceptional improvements in defense offers by law firms utilizing those reports early and often to grow the value of their case when they're still in the negotiation stage early on and having great success. We have rolled out this year our MCP money back guarantee, which makes this decision a no-brainer for you. If you utilize one of our medical cost projections, and if for any reason, whether it be a motion to dismiss or a case that goes sideways or any kind of loss at trial, we will gladly refund the cost of the medical cost projection, so you are never coming out of your pocket to benefit from these reports and the way they grow settlement values for your clients. So the last thing I wanted to share is kind of a new tool that we've worked up, and it's what we call our the true cost of lien resolution, right? So we worked up this Excel spreadsheet, and I just want to share my screen real quick. This is a customer of ours in Atlanta, Georgia, and basically we built this so they could better understand the time and money associated with the lien resolution function and really begin to explore a full partnership like so many of our customers do. So this particular law firm in Atlanta, they resolve about 300 cases a year. Best case, they say they have an average about 1.5 liens per case. And they spend from beginning to end. And so we're talking about identifying the lien, tracking down the lien, auditing, arguing, plan language, everything that goes into a lien, soup to nuts, 4.5 hours of their time, right? This particular law firm, they split the lien resolution function. About 75% is on the staff and 25% is on the attorney, right? So what that means for them is annually they're spending 2,025 hours on the lien resolution function. And what that means to their pocket is it is costing the firm almost $328,000 of real dollars when you consider the time of both a paralegal's time, you know, at a $66,000 average salary with all benefits, you know, fully loaded $99,000 of cost to the firm. If the attorney's output is coming in at around $500 an hour, they're literally spending $328,000 a year on lien resolution. So every firm, you know, their numbers have looked slightly different as we've done these analysis. And if we're even half right in this, there is better use of those monies, better use of those resources than lien resolution when you have a partner like Synergy that can get a great result, that can put more money in your client's pocket, and that can save your law firm real time and energy that you can put into what you do best, right? Which is litigating these cases from beginning to end, getting great results for families, letting us fight out the back end on your behalf so you can move on to the next case. So very grateful for the chance to partner. Thank you for spending this time with us today. With that, I'm going to turn it over to the Q&A panel. Thank you.